when Mick comes out, we're ready to roll. No, I already did.
Yeah, Shane wanted me to remind you just to take us off the record when we're done.
I will. She probably left me a note too. Last thing she wants is for that thing to just keep running.
Yeah, she did leave you a note. I'm not sure where she left it though.
I've only had one other grandparenting time case, and in that one, both parents, even though the couple were separated, said they didn't want her to have parenting time. The mother's mother.
Oh, okay.
And if two parents together say neither one of them wants it to happen, it can't happen. That's the end of the story.
Really?
It has to do with the parental presumption.
I did a little research while we were waiting here. I'll be curious to see what comes out of what Mick has to say.
There was one case in the bench book that talks about a child that was being raised by the grandparent for a substantial period of time, and they said that was good enough. Like it was the only parent the kid knew for most of its early years. But it appears to be a pretty high standard. So, Mr. Fallahy, Ms. Keller wanted to ask me something, but I told her she had to wait until you were back in the room before she did that. Go ahead,
Yeah,
ma'am.
that's fine. Yep.
I wanted to ask you about my PPO.
I can't talk to you about anything other than this case while we're on the record.
According to the
does
clerk, According
does
to
the
the clerk,
PP
my PPO was going to be heard today too. It's on Kimberly because she doesn't take no for an answer. She shows up to my house. She sends mail without
hold
stamp.
on, hold on, Ms. Keller. I don't know who told you that something was supposed to be heard. I don't know anything about that. It's not on my schedule today. I do not have the file. Um, uh, I can try to find out when it was supposed to be heard or why, but it definitely wasn't set on my schedule today, and I do not have the file, so I'm not going to be able to address that today, but I will look into it for you.
Okay, yeah, because they told me they sent it to you and that it would be addressed the same day as grandparenting time because we already had a court
They
date.
didn't, no, they didn't tell me that, unfortunately. But I'll try to get to the bottom of it. If
Okay.
you could follow up, Peter, and find out what happened there. Okay, Mr. Fallahy, the reason I interrupted you is I'm losing my court staff. I don't have any more time to devote to this today. Uh, uh, Whatever happens, I'm going to have to give you a return date to finish this up.
Thank you, Judge, I can appreciate that. I also thank you for giving me a half hour or so here, 40 minutes to look at some of the case law on this. I think I would make a suggestion to the court that could wrap us up today. It sounds like, well, can I give you a 2-minute overview of what I found in the case law, Judge?
Yes, go ahead.
Okay, thank you. So I couldn't find any cases directly on point where our appellate courts in Michigan have determined how to define or what facts would be the substantial risk of harm to the kids. So there is no case that I could see. I went back to 2007 and I couldn't find any cases directly on point for that. So that can be good or bad. That issue appears to be one from an appellate standpoint of first impression, unless I'm missing a case. What I did find is that there was a case, the case of Gearing versus King, and I can give you and your law clerk, your court officer, the site. It's 320 Mich App 182. And Gearing is Geering versus King, King. 2017 case. It's a published opinion from the Michigan Court of Appeals. And the crux of that case deals with whether the parent making the decision to deny grandparenting time is fit or not. And so we have kind of focused our testimony today on the substantial risk of harm, but we haven't, and I got into a little bit with Ms. Keller about her fitness as a parent, but it appears in this Gearing and King case that the court should also analyze whether the parent is a fit parent or not, because before you can get to the preponderance of the evidence standard, it has to be determined that Ms. Keller is a fit parent. If she's unfit, then from what I understand here, and again, I've only read this case about one time, and I tried to go through it as quickly as I could, that if she's unfit, then the whole burden shifting might not apply. So I guess here's the suggestion that I have, and I just talked with my client about it. Since the court doesn't have any more time for us today, and I understand that, we may need to come back. My client is willing to pay for the drug tests that Ms. Keller is willing to take. And so I would ask the court to just put us on, or I can renotice a hearing on for a couple weeks out here on your normal Thursday morning docket. And if we get the drug test results back and they're negative, as Ms. Keller says they're going to be, then my client and I would withdraw the complaint for grandparenting time because we tend to agree with the way the court was leaning today. If the drug test comes back positive, then I think we need to explore the fitness or lack thereof of Ms. Keller. So that's what I would ask the court to order, and I would ask the court to order that it occur today at Adam, that the sample not be diluted, and that that my office just gets a fax copy from Adam on the either 10 or 12 panel drug screen. And I think that might be a dispositive way to resolve this case.
So, I mean, doesn't Adam need something? Can you just walk in there as a private party without a court order and ask them to test you?
I think that they need a court order, Judge. I understand you're leaving here shortly. I mean, I can draft a one paragraph court order that just says Ms. Keller appears for a 12 panel, drug and alcohol screen today, or just a drug screen, I guess, and get it over to you for signature. If that's something that you're willing to do, but I think that would be the best way to proceed given the time constraints today and to move forward on that specific issue of fitness.
Won't they ask for money today?
They will. And I guess I didn't ask Kimberly that. Kimberly, can you go down to the Adam program and make that payment today?
Yes.
Do you know how long they're open down there?
I believe they're open until 7 p.m. So I think they're open every day, Judge, from 6 a.m. to 9 a.m. and then from 4 p.m. until 7 p.m. unless their hours have changed because of the pandemic. But I'm relatively certain that they're open until 7. And if for some reason, it can't be done today, and again, I don't know why it wouldn't be, because I think everybody is located right here in Jackson. It shouldn't have any problem getting there by 7 today.
I have a question.
So you go ahead with your question, ma'am.
For one, I'm not on trial, and I've had CPS called on me multiple times by several different people. I've never been proven unfit. My children have never been removed from my home. When I couldn't take care of my children, I allowed them to stay with my mom. Kim is trying to diminish my character, and her lawyer's trying to bulldoze me like I have no say or authority or of anything on my children. They already stated they didn't want to go.
They said that.
All right, let me stop you, ma'am. You had indicated earlier that you were willing voluntarily to submit to a drug test.
I am, but I don't understand why.
Hold on. Let me finish. What Mr. Fallahy is proposing is that your test comes back negative, they drop this matter, and that's the end of this hearing. If it comes back positive, that just means we've got to spend more time addressing the situation.
So is Kimberly going to do a drug test too?
Well, her testing isn't at issue here, but
why isn't it? It's supposedly that's why I'm not fit for my children, is because of my past. That's why I'm not fit for my children. But how is she fit for my children when she lost her son?
I'm only concerned about the present, ma'am. I'm not concerned about the distant past.
And that's what I don't get, Your Honor. Both my children told you no, they didn't want to go.
If you're, I cannot order you to take a drug test.
Okay, why is the kids what they said?
But I can, if you are willing to take one voluntarily and you pass it, then this whole process comes to an end.
I'm not doing anything to satisfy Kim. She's been harassing me since all this started. All right,
so Mr. Fallahy, it sounds like that's not going to work.
Ask him why he's not.
So what I'll do is I'll get with Dawn. She'll get with you, find another date, and we'll bring you back in and we'll finish this up. I'll probably set it a little earlier in the day, and I won't set it on a Friday, so that we have ample time to plow through whatever remaining evidence I need to hear.
Your Honor, thank you, Judge.
How come what my children said back on December 17th ain't going into consideration here?
To him.
They talked to you on the 17th.
So hold on, Ms. Keller. I don't even get to the question of whether or not your children want to see their grandmother unless Mr. Fallahy and his client are able to establish this threshold. If they establish the threshold, then I'm required to review what's called the best interest factors, one of the best interest factors, one of, I think there's 12 of them, is the reasonable preference of the child. The reasonable preference of the child is something that I absolutely do consider, but it's not the only factor. I have to look at all of the factors. I can't just simply say based on one single factor that therefore it's not in their best interest to visit. I appreciate what you're saying, ma'am, but I have to follow the law. That's what I've been trying to do here all day.
And,
Okay.
and Judge, I don't mean to interrupt you or Ms. Keller, but I do think you have the authority to order the drug test in this case. And I think it's telling that Ms. Keller is not willing to now take one when my client's willing to pay for it. Because, you know, the way that I read this case that I just gave to the court, her fitness is at issue. And if we're
Well,
going to
let's do this. I certainly in custody cases, there have been occasions when I've ordered a drug test. This isn't a custody case. This is a parenting time case. And if you're going to request that I order a drug test, you're going to have to provide me with some authority for that. What I would suggest you do, if you think you can find some authority that in this situation would allow me to order a drug test, I will certainly consider that, but I think you're going to have to do it by motion so that I have some authority in front of me. This isn't a custody case. And I realize fitness, based on what you're telling me, can be an issue. I'm not going to do that without some clear authority that I can do it.
And I guess my quick response, Judge, is I'll look for that, but I don't think there's going to be any case law that says you can or can't order a drug test. I'll try to find that, but when the fitness of a party is involved, and we've got an allegation from my client that she specifically heard Ms. Keller ask Grandma Linda for pills back in September of 2020, it sure seems like there's a valid basis. And I guess, you know, from the general equity perspective of the circuit court, it sure seems like there would be authority to do that. Again, if I need to file a motion, I can, but highly unlikely. There's probably no cases in a custody case where it even says that you have the authority to order a drug test, but I think the court has the discretion to do that.
What I heard your client testify to is that she heard half of the conversation. So I'm assuming it was from something that was said on her half, from which she assumed that. She didn't say she could hear Ms. Keller during that conversation.
I thought that was her testimony, Judge, that she heard Ms. Keller specifically say that.
No, I heard her say that, but I heard her say before that she could only hear half the conversation. So if she could only hear half the conversation, how could she have heard Ms. Keller say anything at all?
Well, I mean, I guess I can. Do you want to ask her, Judge? She's right on here right now. I don't know. I guess I thought she said she heard Ms. Keller specifically ask for.
I know what she said, but I also know that she said before she said that she only could hear half the conversation. And I think she assumed from something that was said in the half that she could hear that Ms. Keller had asked. But if she could only hear half the conversation, she couldn't have possibly heard Ms. Keller ask for Vicodin. So in any event, it's 4:30. We will find a new date to get you back in here. If you have some authority for me to order a drug test, I'm certainly willing to consider that.
Thank you, Your Honor.
All right, thank you. We'll be adjourning. You'll get notice of a new date. And Ms.
Okay.
Keller, you'll have ample opportunity. I know there are a lot of things you want to say. You will have a chance to say them.
Okay, and sir, what about my PPO? Do I need to refile it or something? Because obviously Kim's not taking no for an answer.
I said that I would look into it. I don't know what people told you,
PPO filed on December 8th that you denied.
And no hearing was scheduled on that.
No.
Yeah, there's no indication that any hearing on any personal protective order has been scheduled in front of me. So what happens if you file for a PPO and I don't believe that there's an immediate threat of harm, I will typically deny it. And then you have the ability to request a hearing on whether or not I'll issue one. There's no indication in the court file that you asked for a hearing.
I didn't know about that. The clerk officer, the county clerk called and told me that it would all be heard in one day when we do the grandparenting time.
I don't know why anybody would have told you that. We'll try to follow up, ma'am.
Okay, thank you.
All right, that concludes our hearing.